Hello and welcome to the Inside Risk and Compliance podcast. I'm your host, Adam Spencer, Director of AJ Fox Compliance, a specialist recruitment agency focusing on all things law firm risk and compliance. I have seen so many people carve amazing and fulfilling careers in this space, and it really has been a pleasure speaking to people who enjoy doing what they do every day. However, one thing that has really stood out to me is how hard it can be for people to access the bigger picture outside of their team, outside of their firm. We created this podcast to share with you some of the insights, experiences and stories of the most interesting people succeeding inside risk and compliance. This week we spoke with Jonathan Bray, Director of Jonathan Bray Limited, a specialist law firm risk and compliance consultancy. In today's episode we discussed the pitfalls of dealing with outcome-focused regulations, what an ABS actually is, as well as discussing some of the new challenges on the horizon for law firms and their risk and compliance teams. Enjoy. So John, welcome to the podcast. How are you doing?
I'm great. Thank you very much. Yeah, thanks for having me on.
Nice one. Well, it's fantastic to have you. So for the benefit of the audience, we've done a bit of an intro already, but can you just explain a little bit more about who you are and what you do?
Yeah, well, I'm John. I'm a solicitor by trade and moved into risk and compliance consultancy about 14 years ago.
Okay.
So I run a compliance consultancy called Jonathan Bray. And if I had my time again, I would not call it my own name. And yeah, we work with lots of law firms up and down the country, helping them out with risk, compliance, regulatory, AML, all the normal stuff.
Awesome. And how did that journey start then? So you said you practiced as a solicitor previously.
For a short time, yeah. So I qualified around 2008. And when that came to an end, I kind of fell into risk and compliance.
It's a common story.
Yeah, it's kind of an accident, really. I mean, I finished in the law, around 2010, which was a period of quite big upheaval in the legal sector, particularly on the regulatory side. We had Clementi review with resulting in the Legal Services Act came in, so we had ABSs on the horizon. We had the regulator was just bringing in these new COFA obligations. We had a new rule book, the outcomes focused regulation. The SRA itself was relatively new; it'd only been born in 2007. So yeah, it was a period of big change, and there was a lot of firms who had no idea what was going on. So it was a good time to set yourself out as somebody who at least had a modicum of an idea about what was going on.
I was going to say, for a lot of the listeners who might not have been involved in the legal sector at that time or before that time, I imagine they might not be able to imagine what it was like before outcome-focused regulations, before COLP and COFA roles. So, could you paint the picture? What did it actually look like before that point? Were firms completely taken unaware by these new levels of expectation?
Yeah, well, before that, it was all rule-based. So you had a rule book that changed every 7 years or so. But they were iterations of the same rules dating back, several decades. So everybody was familiar with that and comfortable with what you could and couldn't do. And if you were unsure, you'd look in the book and it would tell you what you could and couldn't do. And then outcomes-focused regulation turned that on its head. It said, well, it's up to you to decide what compliance looks like. We'll give you the broad framework of what you need to achieve, but how you get there is up to you. And then, if you can imagine a solicitor who's used to following rules, all of a sudden they're rabbits in a headlight thinking, is what we're doing right? How do we know? Do we have to get to problems with our regulator before we actually find out that we've done something wrong? Are we just being given enough rope to hang ourselves with? So there was lots of anxiety around that time, particularly amongst the compliance officers. who again had fallen into these roles. Some were just unlucky; they'd just been nominated as compliance officers, but there was no real background to that role.
Mm-hmm.
And it was drummed into everybody from day one that was a role that carried all this personal responsibility, and that you were directly liable to the regulator. You were effectively the regulator's eyes and ears within your firm. You were the internal police, and that's a huge change for somebody within a law firm who previously would have been a manager, a fee earner, but certainly didn't have that personal responsibility for compliance.
So for these firms to have somebody externally who can come along and say, actually, I have hopefully got my head around this to some extent, I can help you out, it must be a huge relief, and especially at that time for a lot of firms, right, to have a consultant on board. How did you skill yourself up then? Because it must have been new for you as well.
Yeah, I mean, these days I'm a big believer in fake it till you make it. There was a lot of that going on at the time.
Really?
I mean, I just had to teach myself. There were some good practitioners out there who were putting on the usual sort of CPD type courses. I sent myself on pretty much everything that I could around that time. Before I launched the business, I probably spent 9 months just skilling up in terms of attending everything, speaking to whoever I could, reading all the books. I started writing as well just to formulate my own thoughts around compliance and what that looks like in practice. And so yeah, it was sort of self-directed learning.
Yeah, and how does it differ, I guess, when it's not rule-based because it's outcome-focused? Presumably the learning approach itself is different because of that, right? In the sense that you're looking more at principles and the overall spirit of the guidance. Absolutely.
I mean, that's if you wanted to, you could do away with all of the handbook pretty much and just concentrate on those very broad principles that they've got right at the beginning. It would be, I think they're 8 now, I think, principles. And you could just concentrate on those, and they should guide you in whatever practical scenario comes up.
And does that work in reality? Or obviously, firms are having a lot of struggles with how to interpret those things. So is there a gap between a true understanding of the principles and the guidance and reality, or where's the sort of room for error? Because I know we were sort of talking before about having a bit of a bugbear, I guess, with some of the guidance of the SRA not being as clear as it could be.
Yeah, I mean, guidance is tricky because we've gone down this route of having a very slim, focused code of conduct. And rather than just leave it there, what the SRA has done is supplement it with additional guidance. And I can appreciate why, because of course practitioners they want definitive answers. But unfortunately, what we've ended up with is a bit of a halfway house, because we've got this raft, and this is growing raft of guidance that comes out from the SRA on a regular basis. And it's technically not part of the rule book, so you don't have to follow it, but you'd be pretty brave if you didn't. So in effect, they become these sort of de facto rules, and which is fine, I suppose, but they're not searchable. You go on if you
I wasn't aware of that. That was something you mentioned that I just thought was mind blowing.
Yeah, I mean, if you wanted to learn out about, I don't know, the banking facility rule, in the accounts rules, you would think that you would just go to the accounts rules, you would read the rule, and that would tell you everything that you need to know. But then there is supplementary guidance, and then from the guidance there's supplementary case studies. But all of these things, they're sort of dotted around in different places. So if you were new to the area, you wouldn't really know where to look. And the other thing is, all this guidance, it changes. So it doesn't stay static. It's not subject to any consultation. So, a regulator can just change it whenever they feel like it. They tend not to give you, when they do change something, they tend not to tell you what they've changed. And so it's not the best way to give clarity on the rulebook.
It sounds very challenging. So if you're looking at a particular piece of guidance, is there anything that indicates that it has changed recently, or can you see any sort of trail or journey with that piece of guidance itself?
No, it's pretty well hidden.
Really? I came across a website a while ago. I haven't used it myself properly, so I don't know how well it works, but I'm sure there's a website where you can sort of go back in time on the internet and look at what a certain website looked like 5 years ago, 3 years ago, 2 years ago. So maybe that's a way to sort of get access to the older guidance. Do you think there's a reason they don't keep that data live?
I don't think there's a good reason. But yeah, I always tell people if there's a piece of guidance that you've been relying on, just PDF it. Just screenshot it, save it. That's what you hung your hat on at the time, just in case it changes.
Do you download it all? Because it makes me wonder whether someone out there could have downloaded every single piece of guidance and have that catalogue that doesn't exist online at the moment.
Yeah, we do. We do a lot of PDFing.
Yeah, I can imagine.
I just wanted to take a moment out to thank our amazing sponsor, the International Compliance Association. The ICA are the leading professional body for the global regulatory and financial crime community, offering professional qualifications, world-class events and training. Go check them out online, and if any of the certificates or courses take your fancy, then you can get 10% discount using our code AJFOX10 at checkout.
Another thing I wanted to talk to you about is I know you're really involved in helping law firms who want to structure themselves as ABSs, and I thought it might be interesting for those listeners who are not aware to understand what an ABS actually is. And I know you talked about in some of the discussions we'd had previously about the fact that people who maybe have a sort of entrepreneurial approach to selling legal services are often involved in these sorts of businesses. And on the flip side, we've seen, some ABSs have significant problems recently. So it'd be interesting to know, what is an ABS and what are your thoughts on ABSs and the future of ABSs?
So I love ABSs. This is the bit of the job that I find the most interesting because I tend to come across some really interesting people in this area. Not all of them lawyers, people are coming into legal services for the first time, and they tend to be excited and be full of good ideas and fresh thinking, and that's really why I love it. An ABS is essentially it's a regulated law firm that has some form of non-lawyer ownership or control. So either it's got non-lawyer or corporate ownership, or it's got non-lawyer directors or partners. That's essentially it. It's regulated in the same way as a traditional law firm. There are slight differences in the fining powers that are available to the regulator, but those are becoming less important as the regulator gets increased fining powers for traditional firms.
What's that, just out of interest, because I wasn't aware of that. So is there a lower level of fining power for an ABS, or is it a greater, or is it more nuanced than that? Greater.
Yeah. Okay. So technically the SRA has got the power to fine an ABS £250 million without referring them to the Solicitors Disciplinary Tribunal.
Okay.
I mean, in reality, that would never happen, I don't think, because it's a statutory power. But they would, anything remotely serious on that scale, they would go through to the SDT, which has got unlimited fining power anyway.
And is there a particular rationale to that difference in approach to a traditional partnership?
I think it was probably something to do with the way legislation was negotiated through Parliament.
Right.
And probably one of the safeguards against non-lawyer ownership. Because of course that was a huge issue. It was still, UK is still one of the very few jurisdictions in the world that will allow non-lawyers to have ownership in a law firm.
And do you think there are inherent risks with that model that are different to a traditional partnership? And I guess maybe from a compliance perspective, do you see it as having an impact on the culture around compliance?
Do I think there are inherent risks? No, because I don't think lawyers have got a monopoly on being ethical, being compliant, doing the right things. There's plenty of examples where regulated people have done the wrong things and got themselves into trouble.
I guess it's whether you see if there is a trend, or if you notice a different approach to compliance or risk management, typically within an ABS, because I guess you've got a leadership that is, like you say, bringing in non-lawyers as well, and whether that means that the view of how risk and compliance might be dealt with could be different.
Yeah. So what we tend to find is that people who are new to the profession, they want to make sure that they're doing everything properly. So they're staying on the right side of regulation, and so they do tend to actually put a greater emphasis on compliance as a function, and they want that to permeate throughout. So they, maybe because they're only too conscious that they are under the spotlight as non-lawyers within a law firm, fish out of water, and there's perhaps more of an anxiety that the regulator is going to target them for that reason. So they want to make sure that everything is as clean as it can be, and there's nothing there. They are whiter than white.
Yeah, and you said you love working with ABSs. Is there something in particular about working with an ABS, or just ABSs in general, that's sort of exciting and different to working with a traditional partnership?
I do. I love being at the beginning of that journey. So you'll have somebody who's got a really new idea, or they come to the profession with fresh ideas about how they're going to improve legal services. They're going to do things better, whether that's just from a just a client service perspective, or they've got they might have a piece of tech that they're going to utilize, or they've got a process that they're going to follow, or they're going to have a referral model, which or a marketing initiative which solicitors don't tend to pursue. And you can be at the beginning of that journey, and you go through that authorization process, and then once you get that license, it's happy days. It's they're then free to go off and execute their plan. And from our point of view, it's a great model, because we get to 9 times out of 10 we stay with that firm as it grows within its first 2, 3, 4 years, and become. I like to think as an integral part of their team.
And do they tend to be? I just would assume, as now it's not an area that I'm particularly familiar with, but the assumption would be they tend to be fast-growing businesses rather than, for want of a better phrase, a sleepy traditional business somewhere else. Is that the case?
Some are, yeah, some are, because of course the structure allows you to bring in non-lawyers and external capital. So some ABSs will be quite fast growth. They'll be quite aggressive. Others will essentially look like a traditional practice. They'll just have a non-lawyer element to them, and I think the license itself lends itself to future flexibility.
Yep.
So commercial flexibility. So they will always have the option of bringing in external money, or structuring things slightly differently, putting in a top company, whatever it might be, or bringing in perhaps a marketing director as a partner. That gives them that a possibility to become perhaps slightly faster growth, but yeah.
So do you expect that we will see more and more ABSs, and it will just continue to grow as a model for selling legal services?
Yeah, it won't shrink. I mean, I think we saw the big explosion, if you can call it that. Lots of low-hanging fruit ABSs happened around sort of 2015 to 2018-ish.
Yeah.
Lots of claims types businesses, personal injury, all the businesses that were heavily reliant on non-lawyer partners. That all happened quite quickly. I think if firms setting up now, it's 50-50 whether they would become an ABS or not, because you can engineer the status if you wanted to, right from the start. I think firms who are not an ABS right now, there has to be a commercial imperative to actually want to convert. You wouldn't do it for no reason.
Yeah.
But if you were starting from scratch, you might take the opportunity to do it from day one.
Are there concerns that firms have, with the transition to that business model that maybe make them hesitate, that you would be able to sort of address and say, look, actually, it's a straightforward process?
I mean, it can be a straightforward process. I think the anxiety about any time when you make a regulatory change is that you're putting yourself under the spotlight.
Yeah.
And we see it quite often that you'll put in an application to the regulator for one thing, and then all of a sudden your authorization officer will pick up on lots of minor things that perhaps weren't, all the ducks weren't quite in a row. And there's always, I think, a slight fear that they're going to pick on something.
Yeah.
And often they do.
So it's a warranted fear.
It is, yeah.
But that's what you're there for, to help them.
Absolutely. Yeah.
And on a different angle, I know this is a question that's or a topic that's come up with a lot of the guests we talk about, and you termed it slightly differently, which is trying to manage the view that people have of risk and compliance. And you mentioned a term, fee burners, and not being considered fee burners and being enablers, which it wasn't a term I'd come across before. But what is your view on how firms can position or sell the concept of risk and compliance in a way that gets the wider business on board?
I think risk and compliance has become such an integral part of legal practice. It's as important as the person bringing in the money on the client side, because you're safeguarding the firm and everyone in it. So you are the you're the goalkeeper, essentially. And so I think rather than the function being sort of seen as a collection of people who say no, it needs to be positioned as a function that is enabling the business to do what it wants to do in a way that's safe, in a way that's not going to attract regulatory attention, it's not going to cause reputational damage. I think it's a business critical function as far as I'm concerned.
Yeah, absolutely. And last question, I know we asked you what you would perhaps like to hear about in a podcast, and one of the things you mentioned was news and development and change within the sector. So from where you're sat, do you have any views about what the sort of big issues are on the horizon for law firms and ABSs to deal with?
Yeah. So I think there's loads. So there's loads of change. One of the things I think most firms are going to find an increasing challenge is anti-money laundering and the way that the SRA is prosecuting those cases. They've become so aggressive in their fining for relatively minor issues. I mean, they're fining small firms, 15, 20, 25,000 pounds.
You see it almost every week. I see something online, another fine.
And it's not because those firms have gotten involved in money laundering. it's because they didn't have a policy in place or a risk assessment in place. These are the administrative side of money laundering compliance that are getting hefty fines. That's a huge challenge, and that's not going to go away. So I think every firm has to get to grips with it, like it or not. Other change. I think the SRA and the other regulators, Legal Services Board for one, are very interested in the culture of law firms. They're very interested in making sure that there's this sort of speak out culture. That everybody is treated fairly and what have you. That's very difficult. That's easy to say.
It's hard to actually
test it. And it's hard to say what good looks like. Every firm is going to be different, and I've heard of lots of firms who are starting to think about doing things like cultural audits and trying to test what their culture looks like. I think from a risk point of view, it's a really interesting one because you can't. It's not something you can. You're not looking at a rule as such. You're looking at a collection of people and psychology and group dynamics and
are there specific outcomes, I guess, that they will be looking for in terms of a culture? Are they looking for a culture that allows certain specific, more measurable things to happen? Or is that yet to be determined?
I think that's yet to be determined. At the moment, they're setting these sort of these outcomes, which are, you must not allow X, people to be discriminated against, and if you come across these behaviours, you have to tell the regulator. You have to challenge that behaviour. But I think there is a broader move towards firms being more conscious of their own culture and fostering what is a positive culture rather than a toxic culture. But the difficulty will always be what good looks like, I think, and how you translate that into real world actionable stuff.
Yeah, definitely a massive challenge. Well, John, look, thank you so much. That has been really interesting and insightful to get a better understanding of those things. So thank you so much for coming on the podcast.
Oh, thanks very much. I really enjoyed it.
We really hope you enjoyed listening to today's podcast as much as we enjoyed recording it. If you did, please do us a huge favour and share it with a friend or a colleague. The more people we can get listening, the more time and energy we can get into recording more episodes and getting the best guests and the most interesting stories and insights. I want to say a huge thank you to the ICA for their support, to Ty and Karem here in the studio, and a massive thanks to Kat for making sure everything runs so smoothly behind the scenes. Don't forget to subscribe to the podcast, follow us on LinkedIn to make sure you never miss an episode. Thanks for listening.